Okay, this is a special lecture on the Missouri Constitution. I recommend that you have your take-home quizzes out and ready for you to fill in the answers as we go along with this lecture. Before we get to talking about the Missouri Constitution, we first need to say a few words about the history of Missouri and the origins of this state we call Missouri, so that you have an idea of how we get to the Missouri Constitution in the first place. The history of Missouri begins with the purchase of the colony of Louisiana from Napoleon Bonaparte, the Emperor of France, in 1803. In its original incarnation, Louisiana was a huge swath of land, covering roughly 875,000 square miles and stretching from the Mississippi in the east to roughly the Rocky Mountains in the west. Out of this vast expanse of territory, Congress carved several new U.S. territories, one of which was Missouri. According to the process set up by Congress, by which territories can eventually become states, Missouri needed at least 60,000 residents before it was eligible to apply for admission to the Union as a state. It reached that threshold around the year 1819. And so in that year, Missouri applied for admission to the Union, and when it asked to come into the Union, it asked to come in as a slave state. Most of the early settlers in Missouri had come from the upper South states of Virginia, Kentucky, and Tennessee, and many of them had brought their slaves with them. When asked to come into the Union as a slave state, there was actually fierce debate in Congress because this would have given the slave states a majority in Congress, and in particular in the U.S. Senate. At that time, there had been an equal number of slave and free states, and many Northerners were concerned that this would alter the balance of power in favor of the South. In order to resolve that dispute, Congress passed the Missouri Compromise of 1820, which created Maine as a free state and Missouri as a slave state. Maine had originally been a part of Massachusetts, and now it broke off and became its own state, which, of course, being in New England, entered the Union as a free state. And Missouri comes in as a slave state, so they preserve the balance of power between North and South. The other part of the Missouri Compromise is that they drew a line corresponding roughly to the southern boundary of Missouri, the 36 degrees 30 minutes parallel. And they drew that line across the remainder of the Louisiana Purchase territory. Everything south of that line was to be reserved for slavery. Everything north of that line was to be reserved for freedom, meaning the territory north of that line would eventually come into the Union as free states. That was the understanding at the time. Um, so Missouri becomes a state in 1820, and the territorial legislature then drew up the first constitution for Missouri and submitted it to the U.S. Congress for approval. So that becomes the Constitution of 1820. Well, what about this Constitution? Um, the Constitution of 1820 had a number of provisions designed to uphold what we could only describe as white supremacy. Only white males who had lived in the territory for at least 3 years were allowed to take part in the Constitutional Convention that met in 1820. The convention, which drafted the new Missouri Constitution, made slavery legal in Missouri and regulated the treatment of slaves. But it also provided for laws which could ban free blacks from entering Missouri. Only free white males could vote in Missouri, and the right to vote was withheld from free blacks. The 1820 Constitution included the following provisions that pertained to black Missourians. 1. The General Assembly, or the Missouri State Legislature, it was called the General Assembly, was forbidden to emancipate slaves without their owner's consent or without compensating the owners for them. 2. The General Assembly also could not pass any laws forbidding slave masters in other states from bringing their slaves into Missouri. 3. The Assembly could, however, pass laws prohibiting masters from bringing in slaves who had committed serious crimes in other states or territories, and could also prohibit the introduction of slaves into Missouri who had been imported into the United States from a foreign country, meaning you couldn't bring into Missouri slaves who were not born in the United States. This last provision was something of a dead letter since in 1808 Congress had already forbidden the international slave trade or the transatlantic slave trade. The Assembly also, this is number 4, the Assembly also could permit masters to emancipate their own slaves so long as the masters doing so did not owe any debts to creditors that could be settled by the sale of those slaves. So in other words, if you're a slave owner, you're free to free your own slaves, but if you owe money to somebody, a significant amount of money, you can't free your slaves before those debts are settled because they could potentially force the sale of those slaves and use that money to recoup their debts. 5. The General Assembly was further required to pass legislation preventing the entrance of, quote, free Negroes and mulattoes, end quote, into Missouri, and to pass legislation preventing slave masters from killing their slaves or inflicting serious injury upon them. And finally, the 1820 Constitution stipulated that slaves in Missouri would enjoy certain legal protections. For example, slaves who were tried for crimes in Missouri would receive a trial by jury and would have the right to legal counsel. Also, slaves convicted of a capital offense, usually one involving the death penalty, would not be punished in a manner different from how the white person could be punished if convicted of the same crime. So, for example, if the law stipulated that a white person be hanged for the crime of murder, well, then a black person convicted of the same crime would also be hanged, not drawn and quartered or stoned or anything like that. And 3, white people who killed or seriously injured a slave, the word used is dismember, would be punished as if they had done the same to another white person. Now, having gone over these provisions, a couple of observations about them are in order. First, the 1820 Constitution obviously legally codified slavery in Missouri and officially designated slaves and other black persons as non-citizens. Nevertheless, the limited protections afforded to slaves in Missouri under the Missouri Constitution were significant in that they were not typical of the South or of slave states in general. Lastly, those protections, though well intended, would not have protected Missouri slaves from the daily realities of abuse and mistreatment that slaves throughout the United States routinely faced. After the Civil War, Missouri drafted a new state constitution. This is the Constitution of 1865. The most important issues confronting the framers of this second state constitution concern the place of former slaves in the new Missouri society and the treatment of former Confederates who had rebelled against the federal government. Missouri had actually emancipated its slaves before the 13th Amendment to the U.S. Constitution was even ratified, but the new state constitution had to be rewritten to ban slavery and to give black Missourians full citizenship rights. Accordingly, the new Constitution had provisions that guaranteed the right to vote, to hold public office, and to perform other public functions for black Missourians. They guaranteed those rights to black Missourians. The convention that drafted the new state constitution was also dominated by the quote unquote radical Republicans. These were members of the Republican Party who held very harsh attitudes towards the many Missourians who had supported the Confederacy during the war. And consequently, they included in the new Constitution something called the Ironclad Oath. The Ironclad Oath, which stipulated that any Missourian who had engaged in armed hostilities against the U.S. government, or who had given aid, comfort, countenance, and support to other persons engaged in such hostilities, would be ineligible to vote or to hold office in Missouri. So, in other words, if you had in any way supported the Confederacy during the Civil War, you were disenfranchised. Thus, while the new state Constitution of 1865 established citizenship for blacks in Missouri, it also disenfranchised a large number of white male Missourians who had supported the Confederacy, which of course had a couple of significant consequences. First, it greatly embittered the white residents of Missouri who had sympathized with the South during the war. They felt that they had been made into second-class citizens in their own homeland, no less. Second, it also temporarily shifted the balance of power in Missouri in favor of African Americans and the Republican Party, which of course at that time usually enjoyed the vast majority of black support. In the next election, in Springfield, for example, the majority of voters in the city of Springfield were black. Missouri's former Confederates were not, however, to remain disenfranchised forever. The Ironclad Oath was eventually deleted from the Constitution in 1870, thereby removing the restrictions against former Confederates participating in state politics. At the next Constitutional Convention, held in 1875, the major issues facing the delegates to the convention were corruption and unethical behavior in state government. This was a problem throughout the nation in the 1870s, as dramatized by the many scandals going on in the federal government during the same time, particularly in the presidential administration of Ulysses S. Grant, the man who succeeded Andrew Johnson, who succeeded Abraham Lincoln as president. The Grant administration was plagued by scandal throughout Grant's presidency. The many scandals included the Credit Mobilier scandal, also the so-called whiskey ring scandal in St. Louis. The whiskey ring scandal involved federal officials who defrauded the federal government of millions of dollars in tax revenue from liquor excise taxes in exchange for receiving a kickback from the liquor distillers who were supposed to have paid those taxes. In state governments across the nation, moreover, many politicians were guilty of various kinds of corruption and unethical behavior. In the Missouri General Assembly, for example, state legislators passed many pieces of preferential legislation designed to give favors to their friends and businesses that supported them. Railroads, for example, were frequent recipients of the state legislature's generosity. They had also voted to give themselves generous stipends from the state tax revenue to pay for personal expenses of legislators. Consequently, the Convention of 1875 explicitly reduced the legislative power of the General Assembly. In order to cut down on the amount of unnecessary legislation, the Constitution authorized the General Assembly to meet in regular session only once every 2 years. The idea is keep them from meeting, and they won't be able to pass so many bad laws. It also put strict limits on the legislators' spending on mileage, stationery, meals, hotel expenses, and other personal expenses associated with travel and serving as state legislators. At the same time, the powers of the governor were expanded in order to place a check on the legislature. For example, the number of votes required to override the governor's veto was increased. The governor's term was extended from 2 years to 4 years, so he serves for a longer term, although he was also limited to serve at least just one term at a time. He could not succeed himself in office, in other words. Finally, the governor was given, and this is the most important thing, the governor was given a line item veto on appropriations bills, which enabled him to veto specific parts of bills that he considered obvious examples of pork barrel or wasteful spending on legislators' pet projects, and so on. After 1875, there were a number of significant amendments made to the Constitution of Missouri, all of which were instigated by the various reform movements that impacted the state after 1875. For example, in the 1890s, Missouri, like many other agricultural states, was heavily influenced by the populist movement that demanded various reforms to benefit the nation's farmers. Among other things, the populists sought reforms to increase the power of voters over their state legislators, so that legislators would consider the interests of farmers and consumers and not just the interests of big business like factories, industrialists, the railroads, etc. These were also goals of the progressive movement of the early 20th century, which sought to make state governments more democratic and more responsible and more responsive to the desires and requests and wishes of the people. In the early 1900s, many states, including Missouri, in 1808, added the following provisions to their constitutions in order to make their state governments more democratic and more responsive. One provision was the initiative. The initiative basically gave the people in the states that adopted this the power to petition. The voters could sign a petition, and with enough signatures, they could force the General Assembly to introduce a bill and vote on it. Then there's the referendum. The General Assembly, with the referendum, the General Assembly can send a bill to the voters during an election so that they can pass it by majority vote. Additionally, many other states added a third reform, the recall, which allowed the voters to sign a petition to remove state officials, including the governor, from office if he was behaving or performing his job in a way that was considered unsatisfactory to them. Missouri never did add this provision to its constitution. A lot of people thought it should, but it never did add the recall. It did add initiative and referendum, however. The last major change to the 1875 Constitution came in 1940 with a voter initiative that created the Missouri Nonpartisan Court Plan. This reform was designed to remove political partisanship from the election of state judges. It said that whenever there is a vacancy in a state court, this plan does not cover circuit courts. A commission of lay people, lawyers and judges, would be formed to submit 3 names to the governor, who must then pick one of those persons to fill the vacancy. If he or she does not make a pick, if that is to say, if the governor does not make a pick, the commission makes their own selection. That judge serves for 1 year, and then the voters are asked to decide whether the judge should complete his or her term in office, which in the case of the Missouri Supreme Court and the Court of Appeals would be 12 years each, with a mandatory retirement age at 70. So the voters do get to decide if a judge should complete his or her term, but they don't directly choose the judge. This plan proved so popular that in 2008, Greene County adopted it for Greene County Circuit Court judges.